In Decker versus Northwest Environmental Defense Center, we'll see whether an agency's ambiguous rule should be interpreted by courts or the agency itself. The Environmental Protection Agency, or EPA, created the Silviculture Rule, which outlined 4 logging-related discharges that require National Pollutant Discharge Elimination System, or NPDES, permits under the Clean Water Act. Any discharge that is entirely composed of stormwater doesn't require a permit. However, stormwater discharges associated with industrial activity must have permits. Under the EPA's Industrial Stormwater Rule, the term associated with industrial activity only applies to discharges from conveyances that collect stormwater directly related to manufacturing, processing, or raw materials storage areas at permanent industrial plants. Georgia Pacific West and other companies contracted with the state of Oregon to harvest timber from a state forest. Georgia Pacific created 2 logging roads in the forest. When it rained, stormwater ran down the roads into ditches and culverts that eventually discharged into nearby rivers. Georgia Pacific and the other companies didn't have a permit for the stormwater discharge. Northwest Environmental Defense Center filed suit against the companies and the state forester, a position later held by Doug Decker, claiming that the companies violated the Clean Water Act by not obtaining a permit for the stormwater discharges. Before the case was heard, the EPA amended the Stormwater Rule to clarify that NPDES permit requirements only apply to the logging operations listed in the Silviculture Rule. The district court dismissed the case for failure to state a claim. Northwest Environmental Defense Center appealed. The Court of Appeals reversed. The Court of Appeals held that the logging roads were point sources and that the companies needed a permit. The companies appealed, and the United States Supreme Court granted cert.